Hello, everyone, and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. So, these are the two articles that we will be discussing today. The first article is from The Hindu, which is titled as An Anti Disclosure Amendment That Hits Public Health. So, this talks about the very recent patent amendment rules that have been brought by the central government, and basically in that the rules about the disclosure of the information about the patent has have been diluted, and what are the effects and the repercussions of this dilution of the rules has been discussed in this article. And the second one again is from The Hindu, which is titled as Don't Ignore the Women Farmers. So as we know that the anti-farm bill agitations are going on all around the Delhi border, all the way from Haryana, Punjab, Uttar Pradesh, and various other states. So in that, the representation of women has reduced due to significant reasons. And also it has been said in this article that the women have not been given the recognition as farmers, and there are there are other issues, coincidental issues that are attached with this problem. So we'll be discussing that too in this article. And thirdly, we have the news and flash column wherein we'll be discussing the small news crisp points, but I guess we do not have it for today, but rather we have it for our prelims exam. So if you're also preparing for judicial services examination, you can definitely look at the lot of the courses, which is the judiciary test prep course from LawSikho. So we also provide amazing guidance and classes for judicial services examination. The link to this course is available in the description box below. And from the landing page of this course, you can also download free study material for your own help. We are also excelling into various other courses like CLAT, All India Bar Exam, SEBI, etc. You can have a look at them too. With this, let's see that what is the multiple choice question from day before yesterday's discussion, that is from Saturday. Northern Sea route passes through Atlantic Ocean, Arctic Ocean, Pacific Ocean, or Norwegian Sea. So you can write down your answer in the comment section below. And this is the descriptive question from today's discussion. Discuss the importance of patents in intellectual property rights. What are the relevant provisions related to it in India? So you have to write the relevant act, Patents Act about it, the main provisions of it, and what is the use and significance of patents in intellectual property rights. It is to be noted that there was nothing very significant from yesterday's newspaper, so that is why we have not included anything from the Sunday edition. So the first article for the day talks about India's compulsory licensing regime. Now, as we know that while we were in our law school, or even if any one of you is still studying, so we remember that while we were studying the Patents Act, so or the entire nitty-gritties of the patent law in India, one important aspect of it was of compulsory licensing. Now, basically, by patent, what do we understand? That if there is any kind of invention or any kind of novel industrial applicable idea that has been developed by any individual or any group of people or any team per se. So if it stands upon all these standards of getting the patent, then the patent office in India grants it the patent. Now, once that happens, so the person who has been granted the patent, who is known as the patentee, gets the right over his invention for next 20 years. And this is absolute right to commercially exploit or commercially use his own invention. But in the very same light, it is also made mandatory that the very invention or the very thing that has been developed by this particular patentee is of the use of people and has been brought in, or has been made has been given for use by the common people, and that too at affordable rates. Now, for example, let's take an example that there is a person or there is a particular lab that has developed a particular medicine. Like in the very recent scenario, let's understand that the vaccine which we are knowing as the Covishield, which has been developed by the Serum Institute of India. So once this is done and the applicability of it is proved, then definitely this institute will look forward for the grant of patent to this particular vaccine. But what would be the use of this particular vaccine if it is available at rates which are just not affordable by people? For example, if one vaccine is available for 35 or 50,000 rupees per shot. Now, obviously, there would be no use of this patent, and the very purpose of this invention that was to serve the humankind will not be solved. So in such a scenario, it is the duty of the government to make sure that both the patentee as well as the public at large are benefited by this particular invention. That is, by grant of patent, the Serum Institute of India would definitely be given. It would definitely gain commercially, and also a recognition would also be given in the entire market of these medicines and drugs. And if we talk about the public at large, then the people will be able to get the vaccine for COVID-19, and that too at affordable prices, maybe for, let's say, 1,000 or 2,000 rupees, or maybe even lesser than that too. So this was the entire idea of patents that we needed to understand. Now, before we move deeper into this discussion, we need to also understand that what was the system of compulsory licensing that takes place in India. Now, as we know that this particular, like in our example, the Serum Institute would get the patent to commercially use its Covishield vaccine if in as a cure for COVID-19 virus. Now, in this scenario, if at all the government realizes that the patentee, that is the Serum Institute in this case, is not using its invention in the proper direction, or it is not able to provide it to the public at affordable prices, or it is just not serving the purpose for any kind of public benefit, then there is also a chance, there is also a provision in the patent laws in India that this license to use this particular invention can be taken away from the Serum Institute, and the government can compulsorily provide a license to some other person or entity and give the same responsibilities now to this new person who will be the new patentee of this particular vaccine. So please do not consider that this entire discussion is about this particular Covishield vaccine. It's just for an example that we have taken so that it is easier for you to contemplate and understand the entire crux of this complete issue. So this was a system of compulsory licensing, wherein, if at all, the failure is seen at the part of the original patentee to use this particular patented item or invention in the right direction, and to provide it to the public at good prices and to affordable prices, and to give to the people benefit at large. So the government can provide for compulsory licensing. Now, for the grant of this compulsory licensing, there is some particular information that needs to be furnished by the patentee after every year. Now, this is important because obviously, in the lack of information, the government will definitely not be able to understand as to how much benefit has been given to the public through this particular invention. And that is why it is the duty of the patentee to service or to provide this basic information. There is a complete form, which is Form 27 under the Act, which the patentee has to fill after some time, and regularly he has to fill this form in order to keep the government informed about the benefit and the at-large usage of his invention. But recently, the central government published the Patent Amendment Rules 2020 following the PIL, which was filed by Shamnad Bashir before Delhi High Court in 2015. So basically, this entire PIL was about the fact that the person who Shamnad Bashir actually contended in Delhi High Court that the questions that are asked in Form 27 must be made more intricate, and a diversified system of questions should be included in Form 27 in order to get better idea and even a wider idea about the applicability of a particular invention, so that the compulsory licensing can be done in a more effective manner. For example, to make you understand, I'll make you just give you a simple example. For example, currently, let's assume that Form 27 has only 5 questions. Let's assume that's not the case, but let's assume that it has only 5 questions relating the applicability and use of this particular invention. But the PIL here said that instead of just these 5 questions, the questions must be deeper and wider in the scope to completely and more comprehensively analyze the use and the practical benefit that a particular invention has given to the entire society. And that is why the actual intention of the PIL was to make Form 27 even wider and lengthier, so that if the government realizes on any of the following points that the patentee has not been able to fulfill his duties with regard to the usage or applicability of his invention, then the government can easily and in a more effective manner provide for compulsory licensing to some other potential patentee. But on the contrary, the very thing that has been discussed in this article is that instead of making Form 27 wider in scope and increasing the number of questions and the depth of questions, the Patent Amendment Rules 2020 have rather decreased the questions that were there in Form 27, which ultimately would make government more devoid of the information regarding the use of a particular invention. So it actually sought direction to government for strict enforcement of patent working disclosure rules. So these were basically the disclosure rules wherein the patentee or the person to whom that particular patent was granted has to disclose this information about his use, as to how much commercial benefit has he gained from this particular invention, or that to how many people has this invention been able to cater any kind of benefit, etc. So this was the entire disclosure, and it actually asked for a reform of Form 27. But the amendment actually has further weakened Form 27. So this form does not seek the most basic data required for the assessment, that is, total units of inventions manufactured or imported in India. Now, one thing that could actually give the best and the clearest idea about the real and practical use of a particular invention was that how many total units of that particular invention have been manufactured or imported in India. For example, like we were taking the example of this vaccine Covishield. So ultimately, the government could get a good idea if, let's suppose, after 2 years, if you're doing this entire analysis and the government is able to know that yes, for example, 20 lakh of these Covishield vaccines were produced in, or the units of these vaccines were manufactured in India, and thus we can understand that probably 20 lakh people were benefited due to this. So this one clause could have given a very clear idea to the government regarding the utility of this particular invention. But this entire question is completely missing from Form 27 now. And that is why it is very difficult to understand as to how the government will now understand about the real utility of a particular invention. So as it is said that the lack of data could prevent invocation of compulsory licensing and increase the patent abuse, because many a times there is a chance that the patentee might sell this particular right to any person or any institute that would not really aim to provide public benefit but rather its own commercial benefit alone. So there is a high chance that there would be an increase in the patent abuse. So here the Disclosure and Patent Act 1970 provides, Section 146 provides that it requires every patentee and licensee to submit annual statement explaining the extent to which they have worked the invention in India, that how far have they been able to propagate their particular invention in the entire country. And it helps the potential competitors to determine whether the patentee has worked the invention in India and made it sufficiently available to public at reasonable prices or not. And if in case we know that if the patentee or licensee fails to do so, then the government has the power to provide it for the compulsory licensing. So the disclosure is to be made in Form 27 according to the rules of 2003. So this disclosure by Bayer played a crucial role in granting of India's first compulsory license to NATCO for anti-cancer drug sofarinib or Nexavar. So a very good example has been given in this article itself, that once this drug was actually made, this was an anti-cancer drug which was made by Bayer. It is a drug manufacturing company, but due to the disclosure information, the government got to know that Bayer had not been selling this drug at affordable prices, and thus the public at large was not getting any significant benefit. And thus the government of India intervened and a compulsory license was provided to NATCO, and it was taken, the patent rights were taken from Bayer and were provided to NATCO, which was another drug manufacturing company, in order to propagate the use of this anti-cancer drug Nexavar. So this was the entire case, NATCO versus Bayer case, which was the which we know. So now you can also go through this. We already know now what compulsory licensing of patent in India means. And here are the different things. So compulsory license, what are the patents, laws associated with it? We have the Indian Patents Act 1970. Then we also have the TRIPS, which is trade related aspects of intellectual property rights, which is at the international level. So this was a bit complex issue to be discussed. That is why it took a bit longer. Rather, let's move towards the next article for the day, which is a very simple article. So this talks about the women farmers. So the speculation or the hypothesis says that the current farm laws will widen the already existing gender gap in the agriculture sector. Now, this is very unfortunate for us to know and acknowledge that it is not only the other aspects, that is education, employment, etc., in our country that are witnessing gender gap, but rather even the agriculture sector in India is also facing a huge gender gap. Now, let's understand that how is it happening in totality. So the women farmers in India, according to the agricultural census, 73.2% 2% of rural women are engaged in farming activities, because we know that many a times we have seen that due to migration and for the opportunities in the urban areas, many a times the men from rural areas migrate to the cities in search of work, where they work as construction laborers or other kinds of house chores they do, or the common chores they do. And the women stay back, they generally stay back in the villages, and of them 73.2% of the rural women are engaged in farming activities, and only 12.8% of them actually have the land holdings. Now this is very a thing which is very unfortunate to know, that of these 73.2% of rural women who are engaged in the farming activities, only approximately 13%, that is 12.8%, actually have the land, or they own the land. Rather, the reason is that they're denied ownership due to cultural, social, and religious forces. And according to the India Human Development Survey, 83% of the agricultural land is inherited by males and less than 2% only by females. Because as we know, when we have this patriarchal setup of our society, so even when we talk about the lineage in the property rights, so mostly even the property rights in India are also quite much, though now obviously due to the very segment, or due to the very thing that we have for the co-partner, women also have the equal right in property. But still, when we talk about implementation, it is, if we talk about agricultural land specifically, 83% of males inherit the land as their own property, and less than 2% females have them for themselves. Then 82% women agricultural workers belong to SC, STs, and OBCs. And due to this, because they are not the land owners but only the cultivators, or they only work as the laborers in the land of some other person, they are not recognized as farmers by the government, and systematically excluded from all government benefits, like any kinds of agricultural loans, loan waivers, crop insurance, subsidies, etc. And due to this, the deterioration of the social deterioration, or the financial and economic deterioration, further takes place in the case of women. Now for this we can have a very simple example. Like for example, there is a particular government scheme which is available for OBCs. Like for example, there is some kind of reservation in any job opportunities which is available for any person who is from the OBC quota. But to avail that particular benefit, you need to be recognized as an OBC in the eyes of government. For that, you need to have some kind of certificate, some kind of birth certificate, or any particular, a document that is enough to prove you as belonging to the OBC quota. Now, unless you do not have something to prove that you belong to this category, you will definitely not be able to avail the benefit of this employment opportunity or this reservation in this particular job. Similar is the case over here, wherein the women who actually is working just like farmers, and they are doing exactly the same work as the other male farmers are doing in the country, but on the contrary, they are not recognized as farmers by the government because they do not hold the lands in their name, and they are just working on the fields of the other people because they are not given the right to hold the agricultural land due to various, as we have seen, due to various hindrances, social obstacles to say. And that is why they remain completely devoid of any kinds of government benefits like the loans, the loan waivers, crop insurance, subsidies, MSP, etc. And that is why they are further deteriorated in the situation. And if we talk particularly about the farm laws, so as we know that has been no legal right that has been provided to the minimum support price, and thus it would allow the farmers to be further exploited. Now, the women workers are not in a position to understand or negotiate agreements with traders or corporates, and no bargaining power would be ultimately given to the farmers and even to the women farmers in the corporatization of the agriculture. So this is very important, that needs to be understood, that farm bills, if we see from one angle, would not only deteriorate the farmers, which we generally see only as the males being the farmers, but rather the further exploited, the level, or the further exploited class, already exploited class, that is the women farmers in this particular entire class, will be exploited to a further greater level. So this needs to be understood, and thus it is very important for the government as well as for us as being the the general citizens of the country as well, to recognize that women also constitute a very important segment of the agricultural sector in India. So this was all for the day. We hope it was a good and informative session for you all. If you wish to download the PDF for today's slides, you can join our Telegram group. The link to this group is there in the description box below. And for any other information, you can also visit our website, which is www.lawsikho.com. Thank you so much.